This is an examination of the hidden human condition.
This is the Hidden Killers Podcast.
With Tony Bruschi.
We're talking still with Deborah Aherns. She is a former public defender and professor of law at Seattle U School of Law. Continuing on with our conversation about Bryan Kohberger, we were just discussing what is the strategy that is trying to be employed here with a lot of these audacious claims of planted DNA and having an alibi, but we're not going to say the alibi.
He is hoping to establish an alibi through asking questions of witnesses who are already going to be presented by the state. And I'm not sure really what that would look like.
Yeah. The other part to that is there already is evidence pointing to him being there. If there wasn't the phone records, if there wasn't that triangulation and the GPS and all of that, that shows him on the way in that direction at the time of the crimes in the middle of the night, the phone going off for the duration of the crime taking place and then magically turning back on and driving back towards his residence. That's pretty damning right there. And to, I guess, the audacity to say, it wasn't me, as I've been calling it the Shaggy defense. I don't really know how that will help with that evidence being as solid as it is. I would feel like it would read to a jury of he's just making shit up.
I think that you have a lot of circumstantial evidence here. The direct evidence that you have is the DNA. The circumstantial evidence, as you've described, the cell site location information that has him leaving, has him returning, has the phone not connecting for a period of time during which the events would have taken place, the video evidence of his car being in different locations. And so I am guessing you would have somebody who's on the stand who's going to testify about how cell site location information works so that the jury will understand that and will understand how you can create a picture of someone's location from where their cell phone is connecting in. And his attorney would be able to ask that person, hey, you don't have a record of where he was at the actual time of the events? No, because they don't. And you have no way of knowing whether his phone was turned off on purpose, if his phone was just not charged. It's pretty common for people to be going back and forth between those two college communities. It's not that weird if he would have been doing so. And this is just some tremendous bad luck on his part. So you can do all of that. But again, that's all about trying to undermine the state's case and say, hey, jurors, are you really confident beyond a reasonable doubt that this is the right guy? It's not necessarily trying to prove he didn't do it, which would be, I think, a lot harder.
Is their strategy at this point not even so much to prove he didn't do it, but more so, let's create just enough doubt so the state doesn't kill him?
I think that honestly, part of this, and I can't get inside the prosecutors' heads. Sure. I don't know exactly what's going to happen. The jurisdiction in which I worked didn't commonly have a lot of death penalty cases, but the neighboring county did. It had a ton of death penalty cases. And oftentimes what happens is essentially the pretrial process is a very long negotiation process of trying to persuade the state, look, maybe at the end of this, my client will plead guilty if you will take death off of the table. Death penalty cases are very expensive. They're really burdensome on communities. If you can find a resolution to a case that doesn't involve actually trying a death penalty case, that's often preferable for everybody. And so maybe the strategy here is to just give the state enough reason not to go forward to trial and maybe persuade them to offer a life sentence. I'm not sure. I certainly don't know whatever private negotiations might or might not be happening between the attorneys, but maybe that's part of what's going on here.
Where do you see this going in the next couple of months? Obviously, October 2nd is the date that is set for the trial. A lot of people saying this is probably going to take a lot longer than that. Do you foresee anything popping up between now and then that would delay this trial or any sort of events taking place?
I don't know that there would be specific events. I certainly can verify that generally you have a trial date and the trial date comes, the trial date goes, and the trial has not yet happened. Yeah. It's pretty common for both prosecutors and defense attorneys and even courts to have reason to delay the trial. For death penalty cases in particular, the jury selection process is much more onerous than it is for non-death penalty cases. And if you just had some event in the community that made it so that for whatever reason, it's not a great month to be trying to select jurors, that could have the court push back the case. So there are all sorts of reasons why the trial could be pushed back. I don't know if it would be, as I said, any sort of new evidentiary discovery, but just the normal trial process generally involves delays. And particularly in serious cases like this, everyone's going to want both the defense and the prosecution to be fully prepared for the trial. So I wouldn't be surprised if you end up with the trial, assuming it happens, going at a later date.
This is an examination of the hidden human condition
This is the Hidden Killers Podcast
with Tony Bruschi.